Good afternoon, everyone. My name is Laura Bacchus, and I'm the Director of Dykema's Automotive Industry Group. Thank you for joining us this afternoon for our next installment of our Dykema Drives webinar series. Today, we're going to speak about advanced mobility, ADAS, AV, and EV litigation, and the accompanying regulatory issues. If you have any questions during this webinar, feel free to email. We'll probably get back to you afterwards, and there is a chat box. Feel free to put your questions in there. We'll do our best to answer them. If we run out of time, this is a pretty robust program. We'll connect with you afterwards. If you're interested in CLE credit, the forms will be circulated after this presentation. If you're not familiar with Dykema's Automotive Industry Group, we're a nationwide group with 140 attorneys and professionals serving every aspect of the automotive industry. We have several on with us today, but this ranges from litigation, cybersecurity, environmental, transactions, regulatory, IP, and the whole scheme. If you haven't yet seen Dykema's third annual Automotive Trends Report, please feel free to click the QR code. Every winter in December, Dykema surveys in-house counsel and executives in the automotive industry to find out what legal issues that you all are concerned about for the next year. We compile this information in a report with our insight, and we publish it early in the winter. So if you haven't seen the report, it is very informative, so feel free to take a look. And I'm super excited to announce the next slide. We are having our third annual Automotive Legal Summit at the M1 Concourse in Pontiac, Michigan. It's going to be Wednesday, July 23rd. Feel free to reach out to me if you want more information about the summit. We'd love to have some of our folks outside of the Detroit area, outside of Michigan, join us this year if you can. And with that, I'll briefly go through our speakers. We have Jay Logel here. Jay is the head of Dykema's Automotive Regulatory Group. We have Clay Kosei. Clay is one of the team leads of our EAV and Mobility Group. Mickey Stevens is in our Minneapolis office. I should have mentioned Jay's in Michigan, Clay's in Dallas. Mickey's a new member in our Products Liability Group and focuses on automotive product liability litigation and trials. We have Tim McCarthy, who's out of our Dallas office. Tim's focus is on international trade disputes, trade regulation, and he's a member of our AI team. Thank you, gentlemen. With that, I'm going to kick it over to Clay, who's going to talk about the afternoon.
Thank you for that intro, Laura. As Laura said, I'm Clay Kosei, and I practice products liability out of Dykema's Dallas office. And I just want to start us off appropriately with a brief roadmap. So Jay Logel, who's got long experience in regulatory work with auto manufacturers, is going to talk about regulatory issues. My partner, Mickey Stevens, and I are then going to discuss product liability litigation as it relates to autonomous vehicles and advanced driver assistance systems features. And then finally, Tim McCarthy is going to wrap us up with a discussion of IP risk and international risks. And so with that, I will kick it over to Jay. Jay, it seems like it's been a pretty quiet environment with the federal government lately. Not a whole lot going on there, right?
Yeah, there's just not a lot of activity going on. There's no media. There's really nothing in that space. And it's interesting, candidly, on the question of regulatory issues and regulating autonomous vehicle technology, there really hasn't been much going on. There's so many other things happening. The federal approach has been that there aren't regulations in place. DOT, FMCSA, and NHTSA have all issued a variety of policy statements, testing programs, different interpretations, and some regulatory revisions, but there's been no, hey, we're going to really go out and regulate AVs. They're trying to let the market dictate where the technology is going, except for one point, which has been a real thorn in the side, I think, of the industry. And that is something that's known as the Google interpretation from 2016, where the agency said that their rules around driver-related controls and driver warnings equally apply to driverless vehicles. And that has the consequence of requiring AVs to have brake pedals, for example. And while it's certainly possible to have AVs with brake pedals, and there are those on the roads today, the real vision, I think, for most of the industry is a truly design-based vehicle for no drivers and no drivers positionings and things like that. So in this space, NHTSA has really taken a soft approach. There's been a lot of activity in terms of test programs, some policy statements. They added ADAS technology to the NCAP ratings, for example. But ultimately, there's been no core regulation in this space. And this has really been an area where the agency is looking at how to do it, because the FMVSS require certain performance standards, and the agency is grappling with how to develop performance standards around AVs. So in the absence of federal regulation, regulators hate a vacuum, and states have been active in this space. And this also shows sort of the dichotomy between what AVs are. Are they to be regulated as vehicle technology, or are they to be regulated like drivers? And a lot of states have operator-related regulations regarding whether you can test in their state, whether you can just operate in the state, a lot of reporting requirements about the behaviors of AVs on the roads, regulations about whether commercial vehicles like trucks, larger trucks can be on the roads, regulations that categorize between levels of autonomy from the SAE, the regulations there, and then financial responsibility. There's this big question about, well, if you get in an accident with an AV, who has the insurance and who has responsibility there? So a lot of regulations on a local level. And for example, I just give you, San Francisco has been a place where AVs have been on the road as much as any place. And there you've got a DMV regulating the vehicles. You've got the California Public Utilities Commission regulating if you have passenger service. For example, Waymo has passenger service. And then you have the San Francisco Municipal Transportation Authority, which issues policies, not really regulations, but things that you need to follow. And if you're going to operate AVs in any market, you really need to have that layered approach to understand all the different actors who may be interested in what you're doing. So that's regulation of AVs, regulation of ADAS. It's actually even a smaller space. As I said, NHTSA did add 4 ADAS technologies to their NCAP star ratings. Interesting, Euro NCAP has much more active ratings for a lot more technologies than we have in the US. And I think for those manufacturers who are, planning on global vehicles, the Euro NCAP has been sort of the leader in this space, driving the need for additional ADAS technologies. The one ADAS technology that we have had recent rulemaking is FMVSS 127 on AEB. And that was quite an aggressive, I think, regulation in terms of performance at 90 miles an hour, performance at 62 miles an hour, very difficult standards to meet. The auto innovators have said that the regulation is beyond the capability of currently feasible technologies, and they have gone forward with a court challenge. The new Trump administration has delayed the effectiveness of this regulation, and they have granted a petition for reconsideration. So I expect a lot of activity in this space. I think the agency is going to revisit these rules and probably come up with something that's less aggressive and perhaps more aligned with European standards. where the activity really is, because there hasn't been a great deal of regulatory activity, it's in the enforcement side. And I think many people on this call have experienced what that means. It all sort of generates from an NTSB report in 2021 that was fairly harshly critical of NHTSA. They basically said NHTSA wasn't investigating claims, didn't have access to accident information, and didn't have the resources to investigate in the space as new ADAS technologies were expanding. And naturally, NHTSA didn't take kindly to the criticism, and they reacted with a lot more activity. Probably the biggest issue in the response was the standing general order, which requires all SAE level 2+ vehicle crashes to be reported, 1 day, 10 day, 30 day, and then ongoing requirements. And that happened very shortly after the NTSB criticism. And to date, depending on how you want to slice and dice the definition of technology, at least 23 ADAS and autonomous vehicle investigations have been open. Most of them are based on SGO reports that the individual companies have submitted. There was a civil penalty related to incomplete or not fulsome SGO reporting, and that accompanied a consent order that added a lot more reporting requirements for that entity. So the agency is very serious about SGO reporting. The other thing that was interesting, the DOT requested funding in 2022 for 15 additional heads, and they've developed an entire new division in their Office of Defects Investigation to help manage investigating essentially the SGO order. In fact, the budget request says, well, now that we have all this SGO information, we now need to investigate. So the more information just spawns new investigations. So the new administration's here. Obviously, Elon Musk is a big part of that administration. The agency has lots of investigations into Tesla. And when Sean Duffy, who's the new Department of Transportation Secretary, was on the Hill during his confirmation hearings, he was asked whether he was going to shut down the Tesla investigations once he was confirmed, and he said no, he's going to let NHTSA do its investigations. And I think that's what's happened. I think the SGO and the investigation process continues to be ongoing. I think there have been a lot of questions about whether the new administration will get rid of the SGO. I don't see any activity in that space, but there's always something new going on, Clay, as you well know. So who knows what's going to happen on that front. One of the things that NHTSA has regulated recently is electric vehicles. And they issued new FMVSS 305, and it substantially follows the Global Technical Regulation number 20. This is a big win for the industry, because you now have essentially a global standard for electric vehicle crash protection between China, Europe, and North America. One of the facts that you need to keep in mind if you're counseling clients, and if you're particularly dealing with EV litigation, is that the US regulations have been lagging Chinese and European regulations for years. And there could be questions about whether US offerings had the same levels of protection that Chinese and European counterparts have. So it's a practice pointer to always keep in mind when you're defending these cases. The other thing that 305 did is expanded its applicability to heavy-duty vehicles. I'm not going to go into the technical details here, but you have post-crash requirements for light-duty trucks and school buses, not heavy-duty vehicles. your propulsion battery, your REES. There are performance requirements for all levels of vehicles. There are requirements about publishing first responder information, which I think the industry's been really fantastic at for years, really trying to protect people who are facing the new risk that battery vehicles pose. And then finally, I think the thing that's interesting here is the safety design documentation requirements. And this actually isn't in 305 because it's not a performance-based standard like in FMVSS. They created a new part, 561, and the documents have to be produced upon request by the agency. So you as a manufacturer have to create your safety case, and you have to have it ready for NHTSA to request it. There are no recall requirements because it's not an FMVSS, but there are potential civil penalty risk if you don't have it and it doesn't meet the guidance that the agency provides in Part 561. The safety case assessment needs to include at least the following: charging and discharging during low temperatures, monitoring and warning of REES control management issues. There needs to be a thermal event warning for the REES, and risk mitigation for thermal runaway if there's a single cell event. It's not asking for risk mitigation once the entire battery's involved. That's practically impossible, but on a cell by cell basis, there are some requirements. What are the risks in this 305? I mean, ultimately, I think it's a win. The industry seems happy about it, but this documentation requirement's really difficult because there's no clear direction on what is adequate documentation. A lot of companies have safety cases and are building safety cases and reviewing safety cases. Well, Clay and I are involved in some work for one of our clients right now where they've asked us to take a look at their safety case and understand with some outside experts the adequacy of it. And I think that's something a lot of companies need to revisit because there's no clear direction on what an adequate safety case is or an adequate safety design in that space. And I think the real risk from an agency perspective is they could ask for your documentation, and then they might compare it to others that they have available or some other model that they think is sort of the level of that was required for safe design, and say, well, you have a safety defect simply based on your safety documentation. And I think that's a real risk. And obviously this is going to be a target for litigation discovery. And I know I've talked with Clay and some others who practice in this space, and that's a real issue that's going forward. This same safety case documentation idea is also part of some of the AV policy statements, in particular the AV STEP voluntary program also has this safety case idea. So it's something the agency is looking at in a lot of different spaces, and I think is going to be a real challenge coming up for both OEMs and suppliers, because everyone's doing safety case documentation. And with that, I'm going to turn it over to Clay and Mickey to talk about autonomous vehicle and ADAS product liability litigation.
So Jay, thanks for the great presentation. And as we transition, I just wanted to ask, you mentioned there are a lot of, EU, Euro NCAP, ADAS technologies that are being required that aren't yet required in the US. What are some of those? Because we all know those are big drivers. Anything that's required in Europe or done in Europe and not being done in the US is going to be a litigation driver. What are some of those specific ADAS technologies?
Well, some of, they've got a lot of different technologies that they're looking at. Some other monitoring of signage, some other rear impact issues. So they're really looking at, I would say, sort of a 360 perspective on both detecting the environment and crash protection. And there's a lot of technologies there that you could talk about, and I'd be happy to discuss it in some more detail. But those are a couple that I think are pretty interesting, particularly rear impact and monitoring and side monitoring and the like.
Yeah, and I think I know I wrote about there's an intoxication monitoring
Yes.
that either is a rule or it's filtering its way up. Yeah.
Well, it's part of the driver monitoring that they have in Europe, and that they are going to look at intoxication. You know, there's been work in the U.S. about coming up with intoxication FMVSS as well, and they're not there yet. But I think that's going to be a real issue with more driver-facing cameras and that information. There's going to be requirements around drowsy driving, intoxication monitoring. So yeah, there's a lot of technologies they're looking at.
Right. So as Jay said, my partner Mickey Stevens and I are going to talk now about what's going on in autonomous and ADAS product liability litigation. And we're going to do so largely through the lens of a number of interesting case studies from cases we've handled, as well as other reported decisions and cases that we've spoken to our esteemed colleagues at other firms that they've worked on. And so in doing so, we're going to look at performance and manufacturing defect claims. You know, the vehicle did not do what it should have or what it was designed to do. And there's often a phantom steering or phantom braking element to these types of claims. We're going to look at failure to equip claims, which are really proliferating and are really becoming very common. Non-collision, active safety, fully autonomous, and AV and ADAS fleet operation issues. And before we jump into those issues, we want to look at what do regular people think. So this study is hot off the presses. In February, AAA released a study reporting on a survey that it did of users or of consumers generally, and what do they think and feel about ADAS technology. And the answer is that people, they generally like and want ADAS technology. Now this is, or at least they say they do when they're asked about it in the abstract. Whether they truly want it, whether they're truly willing to pay for it, that remains to be seen. And we know that take rates and use rates on some of ADAS technologies are not very high. But the surveys show that when asked about it, as they will be at the end of a jury trial, and divorced from their own decision-making and spending processes, they largely say, yeah, they want it. 64% want AEB, and similar percentages want reverse AEB and lane keep assist. So attitudes are a bit different on fully autonomous vehicles, as we'll discuss a little bit below, but we just want to level set the discussion. And now we're going to jump into those case studies. And my partner, Mickey Stevens, specifically is going to start our analysis. And fun fact, Mickey is an attorney who is now well known to a plaintiff's attorney named Bob Hilliard, who some of you may know. In a recent trial, Mickey got up to argue an evidentiary issue, and Mr. Hilliard said, "Who is this guy? I don't even know who this guy is." And Mickey proceeded to win the argument, and so Mickey is now known to Mr. Hilliard. So Mickey, what do you have to tell us?
All right, thanks for that introduction, Clay. So our first case study that we have is this case named Molander versus Tesla. In this vehicle accident, the driver was fatally injured and the adult front seat passenger and child backseat passenger were both seriously injured. The defect allegations in this case were that the autopilot feature malfunctioned due to design and manufacturing defects, and those defects caused a sudden sharp steer input, which caused the vehicle to go off the road. The resulting crash caused both death and serious injury to the vehicle occupants. Ultimately, the result was a defense verdict on October 31st, 2023. And a little bit of background here, the crash happened when the driver was returning home from a day at downtown Disney with his fiance and her son. The vehicle was traveling at a pretty steady speed with no throttle. So we know that the traffic aware cruise control feature was on or activated, but it was unknown from the data we had whether the auto steer feature was also engaged. There was also an issue that some of the data, some of the vehicle data was lost in a post-collision fire that happened. So with that lack of data, as well as the plaintiff's testimony, this kind of became almost a res ipsa case. On the right of the slide here, we do have the data trace of the steering input or the steering wheel angle that caused that crash, that caused the car to go off the road. And we see that it is a hard steering input or angle to the right. And there really is no apparent significant correction that would, keep the car on the roadway or bring the car back to the roadway before it ran off the road and hit the tree. And here, I don't know if I have there we go. We have an animation from an accident reconstruction expert that some of you may have heard of. He's well known to some of us. His name is Sean Harrington. And it shows the vehicle run off the road, starting in the very left-hand lane, all the way off to the right side of the road. And it really shows that aggressive right angle steer input that we saw on the EDR data of the previous slide. But what we don't see is that steer back. It's not arising to the level of a panic steering situation where the driver is reverting back the other way. And we kind of looked at this and said, well, what happened? Did maybe some wildlife enter the road and cause them to veer like that? We don't really know. We do see that the steer input was aggressive, but not quite to a full panic level. And it was certainly not at the limits of the vehicle's traction. Sorry, Clay, go ahead.
Yeah, sorry. So as Mickey mentioned, many of you may know Mr. Harrington as an ADAS or purported ADAS expert. We got his opinions limited in that case. And one just practical point for when you're dealing with plaintiff's experts, we'll just say this in the abstract. Some of these guys are doing shadow testing and hiding it, not disclosing it. And this one in particular has been caught doing that on numerous cases. So you can't be too careful in your review of the file materials. But in this case specifically, what were the defenses? So here the ADAS safety case was critical. For this vehicle, this system, the auto steer, the lane centering function of the vehicle, it had steering angle and rate limitations that prevented the level of steering input that we saw in this crash. So the steering rate and angle limitations control how far and how fast the ADAS can turn the wheel. And this turn was well outside of those parameters. There are multiple redundant control modules that check the data, that limit the steering inputs. And ultimately, the system simply can't initiate a command of this magnitude at this speed. It's limited. So again, the safety case documents were critical. Your automotive safety integrity level document is going to be essential. In this case, we work with the client to determine the failure and time rating of these systems, these multiple redundant control modules, and the jury was very convinced that by the safety case documentation that the failure rate was 1 per billion hours of operation. Human factors is going to be critical. Your warnings and vehicle design, do they give the driver what is needed to avoid a crash? And in this case, the answer was yes. The cues in the vehicle, it was undisputed that the driver and the passenger knew how the system worked. They had been advised of it by the warnings in the vehicle. The owner's manual was clear. And so it was very clear that the vehicle and everything that came with it made the occupants and the driver aware of how the technology worked. Biomechanically, we found in a number of these cases, it's not necessarily intuitive, but biomechanics have been critical in helping us to paint a picture of what was going on in the vehicle before the crash. And that will be a little more apparent in our next case study. But in this case, they were able to tell us the positions of the occupants within the vehicle. The driver appeared to be normally belted and normally seated. The front passenger was not. the right rear passenger, the child, was slouched over inboard. We could tell that based on his injuries. So everything we had from the biomechanic helps to paint a picture and inform what we know about what's going on inside the vehicle before the crash. And then finally, statistics, stats experts have been critical in showing the safety of the technology overall, the fact that it generally mitigates and reduces harm, and just helping to tell the story of the safety case.
All right. Our next example of a performance claim comes from a case titled Shu versus Tesla that took place in Los Angeles County. The defect allegations in this particular case was that the autopilot feature failed to avoid an obstacle across an intersection due to the design or manufacturing defects that were alleged. There was also an allegation that the airbag inadvertently deployed in a low-speed collision. Ultimately, the result was a defense verdict on April 21st, 2023. And as we can see from the graphics on this slide, this was a case where the vehicle was leaving an intersection, going through an intersection, and the road shifts just slightly right after the end of that intersection. And you can see that with the yellow lines on the left picture there. When the road shifted to the right, the plaintiff's vehicle did not. It continued straight, and that's where this low-speed collision occurred, which resulted in these claims. The black and white image that we have on the right side of the slide is an actual image from the vehicle's onboard camera of this particular intersection that it was going through.
So in this case, the defenses were somewhat similar. On the ADAS issue, the vehicle data simply was not consistent with the driver having her hands on the wheel. And currently, and actually subsequent to this case, I think NHTSA released updated SAE automation levels graphics showing L2 level 2 system drivers with hands off. But at the time, that wasn't the case. So we had vehicle data that were not consistent in this case with the driver having her hands on the wheel. And so then it becomes driver monitoring issue. What are you doing to monitor driver attentiveness? Is it a steering wheel monitor? Is there a camera monitor? And so what are you doing to mitigate driver inattention? And so we're seeing a march towards increasing expectations and demands on the vehicle to save the driver from the results of their own negligent driving. Biomechanically, the driver's injuries were not consistent simply with an airbag deployment. They were consistent with her having some type of a hard rectangular handheld object in her hand. And we couldn't tell the jury what we thought it was, and the judge wouldn't let us show graphics showing what we thought it was. But we were allowed to show a graphic with the driver like this and with an empty hand, right? So the evidence that we presented from the biomechanic, again, informs the liability case, informs the ADAS case, and really has been critical, even though, injury causation and crashworthiness may not really be at the crux of the case. And then finally, again, the stats were critical in defending the technology overall and showing the harm mitigation of these of ADAS systems and just helping to tell the safety story. This I have to harken back to Jay's presentation. This is a Chat GPT generated image for us to discuss ADAS verdicts in the failure to equip space. And Jay did not disclose that he had used AI generated images in his presentation. So I want to give him a hard time about that. But with that, Mickey, do you want to tell us about these failure to equip cases?
Right. So obviously there's been a good amount of activity on the failure to equip front. We've got some examples there listed on the slide. the AEB commitment between the auto manufacturers and IIHS, as well as the issuance of the final rule on FMVSS 127, mean that AEB is not ubiquitous, but it is by far one of the most successful or effective ADAS in terms of harm reduction. With that, we're still seeing forward collision warning claims, and we're seeing forward collision warning claims in a context where it's seemingly to get around cases in which AEB would provide limited or no benefit. You know, we see that in situations where reconstructionist experts agree that, you know, even if AEB would have operated, it wouldn't have prevented the crash, or it wouldn't have sufficiently minimized the crash to result in different injuries or lesser injuries. And, you know, those situations where AEB may provide limited benefit, though that can be due to vehicle speeds, it could be due to visibility conditions, among a host of other considerations.
So in defending failure to equip claims, you know, we're always going to look first at the market implementation. I have on the right a graphic of a case. This was a case involving a mid-2000s vehicle. And the allegation was that the vehicle should have been equipped with traffic aware cruise control, forward collision warning, automatic emergency braking. So, you know, the research showed that these technologies were really at best nascent, you know, during that time periods. Or I'm sorry, during the time period of that vehicle's design and manufacture. And, you know, that's convincing evidence when you have an upwards of 95% of vehicles on the market during that year did not have the ADAS technology at issue. So, you know, that research is going to be a key starting point for any ADAS case. You know, we're next going to want to look at the technology's effectiveness. You know, can it prevent this type of crash? And could it have prevented the crash at issue in this case? You know, would the ADAS have helped? And sometimes the drivers are driving faster than the technology can really sense and take any action. And kind of to dovetail with what Mickey was saying earlier, it can be the case that human drivers are able to, or can potentially sense things in a way that ADAS can't. I think of the example when I'm driving in traffic, I can crane my neck and see around vehicles ahead of me. I can look out further ahead, you know, than the 150 meter, you know, ADAS sensing stack, right? So, so some of the argument that we're seeing in some of these cases that is, you know, they're pointing at forward collision warning, claiming it would have provided, you know, some benefit. We're handling a case now, in fact, that's about to go to trial, and the allegation and the plaintiff's human factors expert claims that the driver of the subject vehicle could have taken action to avoid a crash by swerving or braking with a half a second. You know, if he had been provided an alert, and it's undisputed that he only had half a second to react to it, then he would have been able to do that. So, so the analysis of, you know, that's the analysis of, you know, whether the ADAS can prevent, you know, the incident at issue. Rollout is, you know, is something else obviously to consider. You know, when ABS brakes were rolled out in the, I think, late 90s, when J Logo had been practicing for, I think, 15 or 20 years already. When that technology was rolled out, there was something like a 28 or 30% increase in fatal crashes, right? So the technology is not always do exactly what we would expect and hope it would do on the front end. We don't really see this with ADAS technologies. They're not making things worse. They're generally, especially in the case of AEB, they're preventing a lot of harm. But we don't know that when we roll these technologies out, and we don't know where to prioritize our resources when we roll the technology out. We don't necessarily know when we roll the tech out that AEB is going to be more efficacious than forward collision warning or other ADAS. And we do see, you know, consumer reluctance, again, to use much of the technology. I personally, I'm sure we all know lots of people with late model vehicles, and you know, they have traffic aware cruise control, maybe they have lane centering, and they don't use it. They just don't use them. It's just really, I find to be really common. I like to ask people, about their cars and whether they use the technology. I use the combination of I have a Nissan with traffic aware cruise control, adaptive cruise control and lane centering. I use that every day on the way to work. It's great. It's great in traffic. But if you're not someone that loves gadgets and new technology, a lot of people are not embracing the technology. And then finally, repairability is a huge issue. Something like 30% of repair costs for new vehicles that are damaged in crashes but are repairable. Something like 30% of the cost goes to repairing ADAS, sensors, cameras, the camera sensing compatible, bumpers and hardware. So it's a huge cost.
We've also seen some interesting recent failure to equip claims that went on to become appellate cases. We've got two on the slide here. First, we've got this Maywall versus Toyota case out of Arizona. In the lower court, both plaintiff and Toyota brought cross motions for summary judgment. The trial court granted summary judgment for Toyota, denied it for the plaintiff. And when the case went on appeal, the appellate court held that the lane departure warning feature was not so commonplace and widespread that the public would have come to expect its inclusion in a vehicle. And therefore, the court found that the consumer expectations test was not appropriate. And that overruled the plaintiff's argument for the application of the consumer expectations test. The court also said that there was no requirement under Arizona law to prove a separate defect before the lack of ADAS or a failure to equip ADAS could be considered a defect. So this turns into a situation where a plaintiff doesn't need to prove a vehicle has a propensity to leave the lane or depart from the lane in order to prove that the lack of a lane departure warning feature is a defect. So the Court of Appeals found that summary judgment for Toyota on risk benefit under the risk benefit test was not proper because there was, some facts or admissions that lane departure warning wasn't incorporated and it may have been feasible to incorporate into the vehicle. And finally, the court also found that there was a fact issue on causation preventing that summary judgment. Then we've got this Burkowski case out of New Jersey. And in that case, the court found that an otherwise safe vehicle is not defective because of a lack of ADAS or for lack of equipping of a particular ADAS feature. A motion for summary judgment was granted under the reasoning that a manufacturer had no duty to equip a vehicle with every possible technology under the sun to ensure that the vehicle is accident proof, essentially. So, that also comes with the reasoning that an ordinary consumer is well aware that they need to control their vehicle when they're driving it, when they're operating it.
So very briefly, we're also seeing some non-collision active safety cases start to bubble up. I'm defending, currently a CO exposure case where it turns out that the alternative designed, which is an automatic shutoff feature, that even as late as 2017, that wasn't available in 80 to 90% of vehicles. So again, be aware of non-collision ADAS claims and do the market research to determine what the status of that technology was very early on.
All right, one such example of a non-collision claim is a California case, Harcourt versus Tesla. And the facts of this case involved a 2-year-old child who climbed into a vehicle through an open driver door and ended up accelerating the vehicle, hitting the child's mother and pushing her into their garage. And while technically this is a collision case, it is similar to a rollaway or a park to reverse case. And the result in this case was that a non-suit was granted after the close of plaintiff's case on May 3rd, 2024. And the non-suit was granted on the basis that it was not within consumer expectations to have this kind of ADAS that was, alleged by the plaintiffs as necessary in a vehicle. So while these are a species of an advanced driver assistance system, people are increasingly arguing, like in this Harcourt case, that their vehicle should prevent any potential harm.
So in the autonomous space, we don't have any verdicts yet. The incidents tend to be high profile. There tend to be lots of regulatory involvement, obviously with mandatory SGO reporting. NHTSA and the NTSB are usually all over these. The NTSB usually has some very hot sports opinions about them. State and local authorities are usually all over these as well. Obviously, they're clustered around AV activity centers, in which the Lone Star State, of which I'm a resident, is increasingly the site of. And then crash prevalence. So a plaintiff's expert, well-known plaintiff's expert, recently, should we say, produced a study. It's generous to call it a study, but it argues that autonomous vehicles are disproportionately involved in crashes. It's been criticized, for small sample size issues, number of vehicle miles driven, et cetera. And there's also the fact that this is an emerging technology, and many of these incidents, it's not clear at all that the autonomous vehicle was even at fault. We started this discussion talking about consumer attitudes towards ADAS features. Well, what are they on autonomous features? Fully autonomous vehicles. Nikki?
Right. Well, what we see from the data is that consumers, generally want, or at least they say they want, these ADAS features in vehicles, but sometimes the actual take rates of those systems tells a very different story. We've got a survey that shows over time that consumers are still skeptical about full autonomy or full self-driving vehicles. This is a 2025 AAA study, which shows that 61% of responders are, actually afraid of this type of technology or feature, and only 13% actually trust this type of self-driving vehicle or feature. And we see those numbers going up, and there may be a couple of reasons. One is that we tend to see frantic media coverage of autonomous vehicle incidents, despite the fact that the autonomous vehicle's fault is non-existent or questionable at best. The fact remains, though, that attitudes towards full autonomy are not necessarily, or at least showing in the statistics, as improving.
Okay, so what about fleet operation? Fleet operation increasingly is going to raise issues involving or in which ADAS comes up, and autonomous vehicle operations are also going to arise as a result of operating a fleet of autonomous vehicles. These cases haven't handled any of these yet, but lack of ADAS on legacy rental equipment is something that I would expect to start seeing. Retrofitting, I know that one of our heavy equipment manufacturers offers an after-the-market driver monitoring system that you can put in the cab, and it's not simply a camera. It monitors for whether the driver is being attentive, whether they're being drowsy. So retrofitting. If you're operating a fleet of vehicles, it's going to be argued that if you don't have this type of technology, that you should have. One of our partners alerted me that some of the attendees to this call may operate and rent trailers. I couldn't really think of any ADAS or autonomous issues that relate to that would arise out of that. It's the back end, of a vehicle. You have functioning brake lights. If it has trailer brakes, do you have functioning trailer brakes? But Jay did mention that there are rear impact requirements that are bubbling up in Euro NCAP. So that's something to be aware of. And then finally, property protection. Autonomous vehicles obviously don't have a person there. to advocate, protect the vehicle, and we're seeing vandalism and theft claims. Local authorities often aren't really too interested in pursuing the criminals. So, are you protecting your autonomous property by going after, vandals and criminals, pressuring local authorities to press charges? These are things that we, working on with some of our clients. And, with that, I will turn it over to my friend, partner, and former Domer Notre Dame grad, Tim McCarthy.
Thanks, Clay. Still a Notre Dame grad, in point of fact. I'm going to cover IP risk, particularly pertaining to IP misappropriation and loss in the advanced mobility space, and also international trade regulatory and business dispute risk. So moving swiftly through this stuff, touching the IP risk subject first. I'm sure many of the folks with us today will remember the Waymo v. Uber case several years ago. It was the first big IP misappropriation case in the advanced mobility AV space. Looking back on it now, things move fast in this space. A couple things stand out about it. That case involved essentially one guy misappropriating substantial critical IP, but it was pre-AI, and the scope of that IP that was at issue in that case, in retrospect, was relatively narrow. Nevertheless, that case settled out in the middle of trial for almost $250 million. So I think it certainly alerted the market to the kind of value that is at risk in the development of these technologies and capabilities. Late last year, Q4 of last year, here in Texas, in the new Texas Business Court, that is Texas's answer to Delaware Chancery, New York Supreme Commercial Division, the new dedicated Texas court for complex and high-value commercial disputes. We commenced the second case that is cited here on behalf of our client, Create AI Holdings. Some of the participants here today might know Create AI by its former name, which is Too Simple. Too Simple was, and Create AI still is, a developer of autonomous vehicle technology capabilities in the autonomous freight trucking sector, and in fact was the first company to achieve driver out operations in that space. This case here, which is still in the Texas Business Court, and we've recently filed a companion case over in California, a related contract case, involves multiple alleged concerted actors at senior levels of the company, and involves a much broader, in fact, almost comprehensive range of IP involving not only software, not only AI models in planning and prediction and other areas of those capabilities, but also custom hardware for the autonomous freight trucks. It also has international aspects because our client has operations in China, and the defendant companies have substantial Chinese investment, direct Chinese investment. So it also entails CFIUS and national security issues that we're dealing with in the course of the case as well. And in each of those regards, I think it's probably illustrative of sort of the current landscape for IP loss risk in the advanced mobility space here in 2025, which is to say, with a bunch more players in the space, each of whom is pursuing a different development path to reach the goals. Each of those companies is developing its own suite of technologies, a broader range of IP assets, and potentially, again, with business critical value at risk. Moving on through the slides, we can probably skip ahead to a couple of slides to start talking about protective measures. Moving really quickly, A task that folks I'm sure are acquainted with, IP risk mapping. When you're moving through the development project, the IP assets that you're developing are going to change. Your risk map is going to change. Additionally, moving on to the next one, information security, critical thing. You know, in the Create AI case, again, the allegations involve multiple senior personnel. There's only so much that any information security regime can protect against, but there's a lot of value at risk, and it's something that should be very carefully attended to. You can also achieve something of a virtuous cycle by paying attention to it in conjunction with the regulatory requirements, because as you're working to comply with your regulatory obligations, record keeping, reporting, and so on, like I say, that work can create a virtuous cycle within the organization with regard to information security as well. And then skipping on for the last few minutes here to a topic that is a particular interest on the calendar in these last couple of months, international trade regulatory risk and international business dispute risk. First up, of course, tariffs. Identified in our Auto Trends report from late last year as top concern of 80% of respondents. At this point, you know, right here on the calendar, there's not a lot that can reliably be said in detail about how this is going to look. Broadly speaking, however, it's pretty darn clear that we're entering a new world in this regard. And it's not at all clear that anyone, including the administration, really knows in detail where this is going to go. It seems like they're also kind of feeling their way into this new higher tariff environment. We usually get more guidance about what kind of steps, you know, trade counterparties could take to get tariffs back down. We don't really have that guidance here and now. Additional import control measures. Last year, we had the Biden administration's new measures with regard to connected vehicles of Chinese origin and technology of Chinese origin coming into the U.S. Another issue, unsurprisingly, involving China, but perhaps a little bit surprising in its, you know, in its salience, is the Uyghur Forced Labor Prevention Act. This is the act that was passed to prevent the importation into the U.S. of products produced with forced labor in Xinjiang in Western China. And when it was passed, it seemed like a pretty niche thing. But in practice, it has become subject of much more regulatory activity. That's partly because of what the Chinese government has done in response, which is to deliberately move more production of internationally traded goods into that region to force the issue even more. And so, you know, we've had several matters come up, including recently in the AV space, where clients, you know, discerned that important inputs were being produced out of Xinjiang, and they were going to have to find workarounds for that. That also leading into, you know, the next couple of really brief topics can give rise to dispute risk. We'll come back to that in just a second. In this space, you also still have the longstanding export control regime for dual-use technologies, potential dual-use technologies, advanced AI capabilities, advanced vehicle planning and prediction. So AI capabilities for autonomous vehicles definitely can fall within the scope of those dual-use products and capabilities, as can advanced sensor capabilities and other things involved in development of AVs. So be advised that that's still out there very much as well. And then finally, you've got international dispute risk. Both these trade regulatory issues like the UFLPA, that case that I mentioned, came to the client's attention also as an assertion of force majeure. You also have increased international IP misappropriation and loss risk. And you have the essentially constant condition of international supply chain dispute risk, which is now exacerbated by the fact that supply chains are being reorganized all over the world and now perhaps reorganized. In that regard, you know, what can you do to protect your interests? Number one thing, top of the list always, is pay really good attention to your dispute resolution clauses. Those clauses control how things can get addressed and how they can get resolved, and they can save a lot of money and really improve your chances on the merits. So that covers it for those last two topics.
Thanks. Great. Very interesting, and reminds me of the old saying or the old curse, may you live in interesting times. So thank you, everyone, for attending. Please reach out to us if you have any questions, and have a great day.